Yeah, you're right. Ms. Dees. So tethers, they will make up anything to try to discourage us from doing what we got to do. They're trying to come up with unique, goofy arguments to attempt to derail and undermine what we're all about, what FBA is all about, what ADOS is all about. It's not gonna work. All right. So this Libyan man right here. Okay, let me show this Libyan man. Yeah, this Muslim guy. So this is, let me give you his argument. So he is arguing, as soon as it pulls up. Okay. So he's arguing that FBA lineage-based reparations are unconstitutional. That's literally what he's arguing. He's going to try to prove that FBA reparations are illegal under the Constitution, especially Equal Protection Clause. He's going to say that we, FBAs, can't sue for wrongs done to our ancestors unless we had legal standing or control over their estate. Lineage is a racial proxy. He's going to argue lineage is a racial proxy and thus fails strict scrutiny. He's going to argue that the 2006 in African American slave descendants litigation, aka Farmers Pelman case, it killed all federal claims for reparations. Like, then he's going to argue that FBA leaders and activists are legally illiterate and the movement is doomed in court. And we must listen to him, this Libyan Muslim. We must listen to him. If this North African, we must listen to him if we want to get true reparations. And he takes 33% off top, like a lawyer, like a, lawyer who sues on your behalf. And that goes to Libya, I guess rebuilding Libya. I don't know. That goes to a Muammar Gaddafi statue, whatever. But they get 30% of all monies. All right. So he's been doing this in his controlled environments. He never really talked to people who care to debate this stuff. Right. So we're gonna tackle it firsthand in real time. Now let's go to his arguments. Let's go to his arguments. Let me back it up. The route. Here he is.
Are absolutely right. This is not more about content. Fine, I could take that. People don't want to hear. People don't want to hear what I have to say. I could take that.
No, we don't.
I could take
It's
that. But
usually garbage
I
and
promise you, I'll
nonsense.
give you some of the best content on Black culture and Black American culture and ancient culture. Okay, so this case was argued. This case was argued in 2006 at the appellate level. 2006. This is when it was decided. 2006. That's been almost 20 years.
So he's saying that we're 20 years behind, right? 2006. We're 20 years behind. It's already been ruled that reparations for us is over. We need him to make the correct claim to get monies.
20 years ago. Now, I met the plaintiff. Yeah.
Or for
Yeah. I met the plaintiff when we were doing the reparations case well, there was a town hall in City Hall where I was asked to speak.
227 Kemet is a troll. Just ignore that troll. He said he's a proven scholar. On what? Tell us what he's a proven scholar on. What subject? Is it reparations? Is it legalese? What subject is he a proven scholar on? Go ahead, educate us.
And I was one of
Because if you're a proven scholar on, let's say, marine biology, that doesn't mean that you know about reparations and law and stuff like this. A scholar in one thing doesn't mean or equate a scholar in all things. This is what you fraudulents do. You become a doctor in, let's say you get a doctorate degree in, good, come over here. You get a, come over here. You get a doctor's degree in something like, who knows, engineering. And then you go ahead and teach history. You didn't get a doctorate degree in history, buddy. But he don't have a doctorate degree in anything. That was all hypothetical. He is not a scholar in no way, shape, form. He's just somebody on the internet pretending to be a scholar longer than anybody. Kind of like Umar.
the youngest people to speak at a town hall for reparations in New York City. I was a speaker. So all of these new people talking about reparations, I'm just meeting them. Okay, so in the beginning of the case, here goes the plaintiff lawyers, here goes the
227. If he's a scholar and you follow his work, then surely you could represent his historical scholarship. Let me put that link right there. Okay, so I will allow 227 Kemet to interrupt what I got going on to prove that this guy's a historical scholar. Click that link. Old as Rich says Reggie mad he didn't get paid from Sinetta scamming. Yeah, this guy is a waste of time distraction. That's why I'm debunking his arguments once and for all. He got a degree in something with computer engineering, something like that. But somehow he's a scholar in history. Okay, if he's a scholar in history, then we all are.
defendant lawyers. And what this case was generally about, I'm going to summarize it, was that the plaintiff did.
Yeah, the comments are crazy. No, don't. So he need root work. Wow.
Pelman farmer Pelman, she decided to have a case against corporations that insured slavery, insured the enslaved. Now, so now you would think that she could identify her own relatives that were insured. Okay, that's what you call standing. And the court seized upon that. Then they seized on some other things that we will read about tolling, statute of limitations. They will say that this happened over 150 years ago and the courts can't deal with it. Another thing that they will deal with is the suit should have been dismissed anyway because it's a political question and that the federal courts is not the best venue to deal with this. It should be dealt with Congress, Senate, the president, and in local courts. These are the things that we have learned. Okay, so this is the introduction by the Judge Posner, who is usually pretty fair, but he did law, right? He alerted us to some. Nine suits were filed in federal district court around the country seeking monetary relief under both federal and state law for harm stemming from the enslavement.
So what I'm not going to tolerate is a troll. All right. So some Google Pixel guy come in, I'm gonna kick you off in a second. I can tell they're gonna waste time and troll. Unmute. What do you want? Gotta unmute.
of black people.
Okay, what? Yeah, who's this?
627 Kid.
Huh?
It's 227 Kid.
Okay, what do you want?
You can hear me?
Yeah, hey, you get your microphone
Okay.
together, man.
That's all I'm saying about Brother Reggie. Brother Reggie is a scholar when it comes to African history, our history, American history,
No,
right?
no, he's not. No, he's not. I spoke to him already. He's not a scholar, bro. I talked to him already. He been on my panel like 3, 4 times. He's not a scholar, bro.
Okay, so I'm asking
He did.
questions.
Say that again.
So I'm asking questions. You don't think
I
he
can't.
has some valid points?
Wait, hey, bro. Okay? How do you define a scholar? Let's start with that.
Okay, well, for one, when this brother speaks about, like, for example, his New York City plane, he's
Okay,
been in
hold
there with
on.
those
Wait,
people.
I'm asking you, how do you define a scholar? Because by your definition, I might be one. So can you give me your definition of a scholar?
Okay, someone who has thoroughly researched and studied what they're talking about.
Okay, so I'm a scholar. Okay, so
you're
okay.
saying,
All right, wait. Okay, so I'm a scholar. I research thoroughly what I'm talking about. Matter of fact, everything I talk about, I know what I'm talking about real thoroughly, and I even get you guys to call in and challenge me, and you guys get cooked. So I'm a scholar. All right, now what? Go ahead, mute yourself, but you're not gonna rant. I just want a definition, man, and then I want to challenge your definition. So go ahead, mute. Yeah, but this ain't the let me talk session. Yeah. But listen, just answer the question very briefly. This ain't the let me talk session. Okay, so by your definition, mostly everybody that call in my panel is FBA, we're all scholars. Ex-architect, the Holy FBA Codex, SWLE 44, before vengeance. Okay, so we're all scholars. So now, if we're all scholars, then why did you say he's a scholar? Like, what they got to do with my presentation or my debunking of his presentation? What does he got to? What does he being a scholar got to do with me being a scholar, debunking his presentation or why reparations are unconstitutional? What they got to do with what I'm doing today?
what I think what I was saying was the brother was trying to explain how to do it the proper way in law.
No, but
You know
he's
what I'm saying?
wrong.
That's
Okay,
all I
all
think he
right,
was saying.
okay, okay, yeah. All right, get out of here. Get out of here. The brother trying to explain to do the proper way, bro. His video is published since the beginning of the year, bro. I'm debunking it. Obviously, I'm saying his claims are false and pseudo. They're not legal claims. He's misrepresenting our reparations claim by lying, and you can't even get through 10 minutes of my rebuttal to his claims to discern who's right and who's wrong. You're immediately calling in saying he's right without me challenging his claims. I didn't even, hey, family, I didn't even challenge one thing. And if you talk crazy in the chat, just block him. Don't even time him out. Just block him. Okay. The dude, he didn't even let me try to debunk one thing, even though I debunked him yesterday though. But he probably wasn't here yesterday, so he's here today. It's like, yo, you want can I rebut to one thing before you start glazing him and saying he's a scholar?
In America, not FBAs, right? The enslavement of black people in America. A 10th suit by the Hurdle group of plaintiffs made similar claims but were filed in a state court and then removed by the defendants to a federal court. The multi-district litigation panel consolidated all the suits into district court in Chicago for pre-trial proceedings. Once there, the plaintiffs, all but the Hurdle plaintiffs, about whom more shortly, filed a consolidated complaint, and since venue in Chicago was proper in any event, not objected to by the parties other than the Hurdle group, whose objections we consider later in this opinion. The district court was unquestionably authorized, notwithstanding, right? Okay, so at this point, you can look at what they're saying is you can look at the federal court and that they had jurisdiction. We are also persuaded that a district court to which a case is transferred under the section 1407 can rule on a motion to dismiss the case, even if the plaintiffs have not agreed to let the court decide the methods. So they're saying this court had the ability to dismiss the case, right? Even if the plaintiffs had not agreed to let the court decide the merits, right? Okay, so then they're going to talk about some case law about dismissal, and then he goes, and rightly so. The duty to conduct the pretrial proceedings in a multi-district litigation entails the transferee courts ruling on a host of pretrial motions, many of which, whether or not formally depositive, can shape the litigation decisively. There is no reason to exclude from the court's authority rulings on motions to dismiss. So there were earlier motions of dismiss by the plaintiff, by the defendants, and this court is bringing those courts up, those dismissals up, right? Okay. It says, were it not for the hurdle suit, we wouldn't have to decide whether the district judge could have dismissed the transfer suits had the parties not agreed by filing a new complaint to his retaining them after completion of pretrial proceeding. But the hurdle plaintiffs did not agree, so we cannot duck the question. So the hurdle group did not agree to some activity that happened prior, so this court cannot duck the question. So otherwise, they would have just dismissed it. The suits are a series of mostly identical cases, class actions on behalf of all Americans descended from slaves with whom one or more of the defendants or their corporate predecessors may have been directly or indirectly involved. The consolidated complaint, the hurdle complaint, is similar, so no need to be discussed separately, alleges the following facts, for which do not vouch, we do not vouch, but merely summarize. The complaint having been dismissed before the truth or falsity of the allegations was determined. The defendants are companies of the successors to companies that provided services such as transportation, finance, and insurance to slave owners. At least two of the defendants were slave owners themselves. The predecessors of the defendants who were slave owners of one of the bank defendants once accepted 13,000 slaves as collateral on loans and ended up owning 1,250 of them, which the borrowers defaulted, and the predecessor of another defendant ended up owning 346 slaves. So the court is admitting that the defendants owned slaves, right? Also, the consequence of a borrower's default. Even before the 13th Amendment, slavery was illegal in the northern states, and the complaint charges that the defendants were violating the laws of those states in transactions with slave owners, which is correct. It also claims that there were occasional enslavement long after the passage of the 13th Amendment, and that some of the defendants were complicit in those too. So they slaved them when slavery was legal, they slaved them during the illegal slave trade, and they continued to slave them after the 13th Amendment.
All right. So before you go on glazing, listen to his claims. And then my rebuttals before you start saying he's a scholar. Okay. His first claim, we can't sue based on lineage, is arbitrary, and the Equal Protection Clause bans race or ancestry-based classifications. That's his first claim. His second claim is we are arbitrarily using classification. The 14th Amendment bars reparations by lineage. So far, I've been timestamped it from 35-minute to the 43-minute mark. He said, you need concrete injury, not just your harm to your ancestors. You can't prove harm to you. Okay, so those are his claims. All right, so these are for the glazers of this guy. So now I'm going to debunk those claims and show how they're lies. And he doesn't know law like he portrays to know law. Okay. So first and foremost, he's equating lineage to race, family. Don't let him do that. We're not making a race-based claim. We're making a lineage-based claim for reparations. Lineage, not race. Okay? So lineage is ancestry specific and historically documented. FBA is not demanding benefits. We're not demanding benefits based on broad race categories like Black, okay, but on provable lineage. You heard that word? Provable lineage. Trolls, provable lineage connected to American slavery. That passes, that right there, provable lineage, everybody, provable lineage connected to American slavery. Provable lineage, that passes the strict scrutiny if the government interest is compelling and remedies are narrowly tailored. Okay, so provable lineage connected to American slavery, that passes strict scrutiny if the government interest is compelling and remedies are narrowly tailored, which courts have accepted in other cases. So I just debunked that. Other courts have accepted this, e.g., Japanese internment reparations and Native American settlements. The precedent exists. It's the Cabell versus Salazar 2009 settlement. This shows how the U.S. government has paid billions in damages based on ancestral mistreatment of Native Americans regarding trust lands. Ancestral mistreatment. Okay. Now, it's not arbitrary. Okay. Our FBA classification is based on U.S. chattel slavery lineage, deny access to 246 years of forced labor, plus 100 years of Jim Crow apartheid, block participation in federal wealth transfers, Homestead Act 1862, GI Bill, New Deal, etc. The federal government itself classified formerly enslaved people differently, e.g., Freedmen's Bureau. The president is already there, Freedmen's Bureau. Constitutional clarity. The 14th Amendment was used to create and protect race-based remedies such as affirmative action and federal race-based minority contracting programs. Fuller Love versus Klutznick, 1980. Okay. Economic and statistical studies do quantify modern harm. You try to say they don't. White wealth is 171,000 median versus Black wealth, 17,000. This is based on 2020 Fed Reserve data. Foundation Black Americans were legally excluded from 80% of America's wealth building programs. Dr. Darity's research shows over 14 trillion in intergenerational losses. Harm is cumulative, right? And provable via disparate impact frameworks upheld in civil rights cases. That's either true or false. So I debunked his first three claims. Okay, so now I finally got to rebut something. Now that's when you're supposed to have called in. So it's either what I said is true, debunking him, or what he said prior is true. But both can't be true. You jumped the gun too early, glazing.
Right? So the question is, how do these defendants escape that? Right? How do these defendants escape that? Well, the legal basis for the federal plaintiff's federal claim is 42 USC section 1982, which provides that all citizens of the United States shall have the same right in every state and territory as is enjoyed by white citizens thereof to inherit, purchase, lease, sell, hold, and convey real and personal property. So the defendants are rightly saying that and included that. A claim based on federal statute invokes the federal question jurisdiction of the federal court, but since most of the conduct of which the plaintiffs complain occurred prior to the passage of the 13th Amendment, and indeed prior to the Civil War, that means where slavery was legal, right? Section 1982 does not provide a sturdy basis for retention of federal jurisdiction over plaintiffs' non-federal claims. So they're saying the plaintiffs brought up a case after the 13th Amendment, right? And that bringing up that case does not fix what happened earlier. So that's what the court is saying. Okay, so let me read it again. But since most of the conduct of which the plaintiffs complain occurred prior to the passage of the 13th Amendment, and indeed prior to the Civil War, Section 1982 does not provide a sturdy basis for the retention of federal jurisdiction over the plaintiff's non-federal claims. And then they say frivolous federal law cannot successfully invoke federal jurisdiction. Just to dig into the plaintiffs, which are our people. But with one exception, all of the non-federal claims are within the federal diversity jurisdiction and so do not require a federal law handle. And then they give the exception is the Richard E. Barber Sr. suit for both he and the Brown brothers, one of the defendants in the suit, are citizens of New Jersey. So because there are state claims, this case seems to continue, right? Okay, so then they say the district judge ruled that by virtue of both the political question doctrine and the requirement of standing to sue derived from the Article 3 of the Constitution, there was no federal jurisdiction over any of the suits, and that.
Okay, so keep in mind, we're listening to his argument. He's reading, right? And then we're going to listen to the points he highlights. Those are his arguments. Those are what I'm going to debunk. So I'm waiting while he read, and then when he make a claim and stand on it, that's when I come in. So pay attention before you ask for the link. You should know what am I debunking and challenge that.
In any event, they had no merit because of the applicable statute of limitations had lapsed, and anyway, the complaint failed to state a claim. So the court is saying that the complaint failed to state a claim, and that there's a statute of limitations. It occurred prior to a period that the court could address, right? So here the court is doing their work on Black people. Then they come up with the political question doctrine bears federal courts from adjudicating disputes that the Constitution has been interpreted to entrust to other branches of the federal government. So now the court spits at the plaintiffs and say, you shouldn't even be here. It's a political question. It's not a federal question. Okay, so let's go down and read some more. Okay. They say a case that sought reparations for the wrong of slavery would encounter similar obstacles, but plaintiffs have been careful to cast their litigation as a quest for conventional legal relief, right? So they say to plaintiffs, you are smart. You've cast your litigation for conventional legal relief, right, of what is due in the context of the laws, all right? All the defendants or all the plaintiffs are asking is that the federal judiciary is to apply state law plus one federal statute to the defendant's conduct. They face, of course, now the judge jumps in. They face, of course, formidable obstacles quite apart from the severely limited application of Section 1982. To name one of those obstacles, watch this, family. It is highly, this is the court, unlikely that antebellum laws in northern states were intended to confer financial or other benefits on the 21st century descendants of slaves. It is highly unlikely that antebellum laws in northern states were intended to confer financial or other benefits on the 21st century of descendants of slaves. So they're saying that the old laws, you can't find it in the old laws that it applied to your descendants. Killing the case. But the obstacles to the vindication of the plaintiff's legal claims have the form of at least a conventional defense to a lawsuit. If one or more of the defendants violated a state law by transporting slaves in 1850, and the plaintiffs can establish standing to sue, prove the violation
let's get the
despite
lights
its
up. Tammy,
antiquity,
thank you very much.
establish that the law was intended to provide a remedy, either directly or by providing the basis of a common law action for conspiracy, conversion, or restitution to lawfully enslaved persons or their descendants, identify their ancestors, quantify damages incurred, and persuade the court to toll the statute of limitation, then there would be no other obstacle to the grant of relief. So the court said, give us a case, right? Give us a case that that fulfills all of these, and you will have no obstacle to a grant of relief, right? So they looked at the defendants and they said, sorry. I mean, they looked at the plaintiffs and said, sorry, you can't show a law that would have established you relief, you descendants, right? You can't show us where it actually happened anyway to your ancestors. You can't quantify the damages. You have to identify their ancestor, your ancestors, right?
And you heard him. He said we cannot quantify the damages. Got him.
The harm that's done to quantify damages in the curse, right? And the harm that's done to quantify damages in the curve happened anyway to your ancestors, where it actually happened anyway to your ancestors. You can't quantify the damages. You have to identify their ancestor, your ancestors, right? And the harm that's done to quantify damages in the curve. And then you have to persuade the court to toll, meaning to kind of set aside the statute of limitations. If you can't do that, and it's a political question, it may be a political question, rather than a federal question, off you go. We are going to dismiss any case, any federal reparations case, any federal reparations case on descendants of slavery.
All right. So just to remind you who this guy is. All right. Some call him an agent. I don't know what's going on with this guy. But he said that hold on. He said that we can't qualify what we lost. This is a fool. Okay, so economists already have. So we got Dukes. Everybody keep citing. We got Dukes, Dr. William Darity. We got UMass Amherst, Dr. Andrew Brimmer. And the Federal Reserve have published wealth gaps traceable to denied inheritances, land theft, redlining, and exclusion from the Homestead Act and FHA lending. If damage to an individual's estate was sustained over time, that doesn't make it unquantifiable. One more time for this guy, this Libyan dude, this Libyan Muslim. If damage to an individual's estate was sustained over time, that doesn't make it unquantifiable. Class action lawsuits frequently calculate projected lost earnings. We know that. We know that. Projected lost earnings. Courts in Indian land trust cases accepted long-term extrapolated losses over generations. They accepted courts in Indian land trust cases accepted long-term extrapolated losses over generations. The dude is an idiot agent. Straight idiot. I don't know what he's reading, but either that's wrong, what he's reading, or he's not reading it correctly. So you challenge. So if you're going to challenge anything, you challenge that. All right. Either I'm wrong or he's wrong, but we both can't be wrong. We both can't be right.
We would, Ben says that we would have to tear down the compromise of 1850 and 1877. What do you mean by that?
Yeah, the likes family, it don't take much. Just like the video. When you like the video, that's the least you can do. The least that you can do is like the video. That's all. That's a simple action. I mean, you can send a cash app or a super chat, but that's the most you can do. But the least you can do is just hit the like button. That's all. Thank you. Because we're debunking a video that's trying to debunk our claim. This is a very important video here. We don't want tethers and white supremacists to take this video and shop it around and this become their new talking point. So we're going to debunk it before it even gets off the ground. This plane don't got to land, it will never take off. Like the video, let's get a hold of this debunk so this won't ever go anywhere.
Just help me with that. I think I know what you're saying, but what the court just said is that you have to identify your ancestors and the harm to them, and
I already shown that was already done. Okay, let's move on.
Standing the suit. So
these old tethers, they got to update their information. All the tools, the AI and all this stuff, and they refuse to look at it because they know it debunks them.
Saying you plaintiffs who are suing us, you lack standing. Wow. The defendants' alleged misconduct with the financial and emotional harm that the plaintiffs claim to have suffered, meaning the people who are suing suffered, not their ancestors, right? Not their ancestors, but the people who are suing. You can't connect financial and emotional harm to you. Okay, so how many people see that as a problem, right?
Nobody but tethers and white supremacists.
So, for example, Edna is alleged to have written several insurance policies on slaves in the 1850s in violation of state law, right? Because slavery had ended, applicable to the company and to have obtained premiums for the insurer. The court is admitting that the slave owners that will assume exceeded the cost of insurance to Aetna, its expenses plus the payment of proceeds if the insured events came to pass. The plaintiffs argue that Aetna's net income from that insurance was a wrongful profit that the company should be ordered to restore to the plaintiffs' classes. That is an argument that we should pursue, ill-gotten gains, right? We should pursue that, right?
We don't trust
so the court is
Libyan
hinting
arguments.
Maybe you might have. Okay, so let me see what Nook is saying. Let me see what he's saying. Let's see. Wow, I can't. Let me see if I can see it all. Okay. The compromise of 1877 was an informal agreement between Southern Democrats and allies of the Republican Rutherford Hayes to settle the result of the 1876. So, okay. So, well, you said informal. That's like 40 acres of a mule, right? It's not written into law. And what the court is saying clearly is that you must show, right, your ancestors, right? But the court is going to do something to really tear down reparations for us in a minute, right?
Yeah, I mean, he said for us, ain't nothing for you. That's why he's trying to tear it down, because it's nothing for him. I don't recall Libyans being affected by Jim Crow, plantation, you know what I mean, slavery, Black Reconstruction, the FHA and Homestead Act, and all these things. Reading GI Bill. I don't recall Libyans being tied into that.
So these laws that you have to show your ancestors at that period, and you have to render the injustices to your individual ancestors.
You hear this guy just making up shit?
The class has to do that. So that means if you have a class suit, that means those in your class need to sign affidavits showing their family members in that period. If you do not do that with any expertise, then you don't meet the class specifications. You can't talk about your ancestors that were enslaved. This is how hideous these courts are. All right. So this is where they begin to talk about this stuff. And in any event, it would have distributed any profits from the transactions to its shareholders long ago, all to one side. There is a fatal disconnect between the victims and the plaintiffs. Wow. There is a fatal disconnect between the victims, meaning those who were enslaved, our ancestors, and us that are suing on behalf of them. When a person is wronged, he can seek redress. And if he wins, his descendants may benefit, but the wrong to the ancestor is not a wrong to the descendants. Comments on that?
You heard this fool. The wrong to the ancestors ain't a wrong to the defendants.
When a person is wronged, he can seek redress. And if he wins, his descendants may benefit. But the wrong to the ancestor is not a wrong to the descendants. What's your comments on that?
You are a fool, and you will be debunked.
Because this is murderous to people over here misinforming you that in federal court that we can get reparations. They knowingly or ignorant, right, is suggesting and not talking about this case and not what it says. And this is the last reparations case.
Okay, so two things. One, like the video. Secondly, if you're here for the first time and you're FBA, you might want to make that known, because if you're part of the lineage, you need a lineage wrench. So if you're here for the first time and you could trace your lineage back to slavery, make that known so I can make you a moderator and give you your lineage wrench. All right. And also, like the video, subscribe, hit the notification bell.
So do you see, press 1 if you see a problem with this.
I guess nobody gonna press 1.
There is a fatal disconnect between the victims and the plaintiffs. When a person is wronged, he can seek redress. And if he wins, his descendants may benefit, but the wrong to the ancestor is not a wrong to the descendants. So what is my brother saying? The Promise of 1850 was made of 5 bills that attempted to resolve disputes over slavery and new territories added to the United States. What this court is saying, that a wrong to the ancestor is not a wrong to you. Any comments on that?
Yeah, you sure about that, buddy?
Let's see what's going on here. Any comments on that? How many views do I have? 26, 30,
Yeah,
40?
nobody gonna watch this, buddy.
Let's see.
We don't respect lies and
How many views?
misinterpretation, misrepresentation, or misinformation. We
How
don't
many
represent
views?
that.
Check it myself.
You must be from Mississippi.
named
All
this
this misinformation, misrepresentation,
12 people watching. I didn't even have 26.
All right. So while he's trying to figure out who's watching him, what he's talking about, that is procedural, not prohibited. He's acting like it's prohibitive. It prohibits something. It's not. It's procedural. Got to have your paperwork right. Okay. Got to have your legalese right. So that burden could be addressed legislatively or by statute, e.g., by allowing any documented linear descendant to qualify for class action or legislative reparations. Case in point, the 9/11 Victim Compensation Fund. It did not require each family member to prove executor rights. Government created a mechanism. Okay. How about legal workaround exits? Okay. Federal claims acts and settlements frequently make group level disbursements without individual estate certification, e.g., Black farmers lawsuit and Japanese internment, etc. Dude is a old Libyan fool.
And this is going to be my life on YouTube. YouTubing. I'll get 12 live till people subscribe, and then later on I'll get maybe 100 views. And so I think the people who are watching it now, and I have to share it and let people know that I'm on so that they can subscribe.
Bro, nobody supports lies.
What I'm just doing for you, thank you, Barn Dog. What I'm just doing for you is allowing you to know that a harm to your.
After I'm done debunking him, I will put the link out there for anybody, family time, or even hater time. Haters can click the link as well.
Your ancestors is not a harm to you, right? So someone is playing on the ignorance of our people in the course of talking about insurmountable obstacles that we have to endure on reparations. And for me, this is a personal penalty. If look, a person who owns a channel, they have a right to decide what content is good or not, and that's fine. And I respect. TV says I would disagree, and in my next show, for lawyers to do the case right, I think that it would be a big failure, right? If we did not do a fund, and that's what I talked about in my video. So we could disagree, but that's what the law says. So Solomon TV, thank you so much. So now, let's see. Okay. The plaintiffs introduced another claim of injury by asserting that the defendants refused to violate their own state laws by doing business with slave owners. There would have, if they refused, the defendants refused to violate their own state laws by doing with business with slave owners, there would have been less slavery because their refusal would have been tantamount to subjecting the slave owners to a partial boycott. That would have raised their costs, and by making slavery less profitable, may have reduced the amount of it. Might, watch the court, not would. Here's the court. Might, but not would. Because higher costs might simply have depressed the price of a slave. And had there been less slavery, the argument continues. Some of the ancestors of the members of the plaintiff's classes would not have been slaves, but instead free laborers, and they would have had some disposable income, part of which they might have saved rather than spent, right? But this causal chain is too long and has too many weak links for a court to be able to find the defendant's conduct harmed by the plaintiffs, right? Let me just see, message, I'm online, with your own. Let's just see, I'm online. Okay, I'm online. Sorry about this. I am online. Okay, thank you. Okay, so is it possible to determine how much, if any, less slavery there would have been had the defendants not done business with slave owners, which would affect a diminution of slavery would have had on bequest the ancestors of the class members, and how much? So now the court is really beating up this reparations case, right? They're looking at every little knob.
No, it's not. No, it's not. No, it's not. That's what he wants to believe. Again, it's procedural. It's procedural, right? Present your case correctly, and it would be taken serious. If you don't, it won't be taken serious. That's all.
That they can turn, right, for the floor to fall. Now, they say, they give an example. I don't want to read the example. I think that you get the point. Let's go on. Okay, even if compliance with those local laws would have curtailed slavery, and even if it could be shown, which it could not be, right? The court is horrible. That as a result of the hypothetical curtailment of a plaintiff's remote ancestor would not have been a slave, but instead a free laborer, how could the wages that the ancestor would have earned as a free laborer to be shown to be influenced the wealth of the remote descendant? So whatever your ancestor made, right? How could it be connected to you, right? Let's see what else. Okay, I just checked the chat. All right. So, okay, so.
1 second, my screen froze. All right, let's get back.
Okay, nor are the problems of measuring and tracing alleviated by recasting the relief sought as the restitution rather than the damages. Restitution and transfer of the wrongdoer's gain to the victim is an alternative to damages, the monetization of the victim's loss. Okay. It is a sensible remedy for egregious misconduct, but because it makes the conduct worthless to the defendant by taking away his profit, even if he exceeds the loss to the plaintiff, but it is presumably an injury. So they're saying, well, yeah, it is still an injury. It is a remedy for legal wrong. And there's no way in which to determine what, if any, injury the defendants inflicted on the members of the plaintiff class. So that's where, at the last sentence, that's where they kick us in the back. There's no way to determine what, if any, injury the defendants inflicted, right, on the members of the plaintiff's class, not their ancestors, you, the plaintiffs, you. And again, if there was a legal wrong, it would not be a wrong to any living person unless there was now here's the killer. And again, if there were a legal wrong, it would not be a wrong to any living persons unless they were somehow the authorized representative to bring suits on behalf of their enslaved ancestors. Let me see, Benjamin Sud. I appreciate my small audience. Explain the difference between slavery and free labor. I don't think.
Okay, so before he does that, he keep making the claim lineage is equal to race. Okay, and as he keep making that false equivalence, he's going to find himself in trouble. So he keeps saying lineage equals race equals strict scrutiny equals rejection. So let me just tell you that now all strict scrutiny claims fail. The government only has to show a compelling interest in narrow tailoring. Reparations narrowly tailored to a very specific harmed group, DAS, descendants of U.S. slavery. We, FBAs, we meet that burden. Lineage is more like tribal enrollment or settlement classes, not general racial preferences. So again, I don't know if he's doing that on purpose. He's a type of agent, or he just a fool.
Anyone would give free labor, right? I think that slavery is forced labor, right? And thus the person who is inheriting the labor, right, gets the free labor. The person who's enslaved is in fact being separated from his time and being forced to do it, right? So who would do free labor and have to feed off their family? There is a difference. But in what I am reading, did y'all read that? Press one if y'all read that. Press one if you read and understand that, right? Press one. Let me go and read this again so that you can read, so that you can see it. Benon says there is none. Free labor is if it's voluntary, like I want to volunteer, that's free labor. If I'm forced to do it, then that's enslavement, sharecropping, things like that, forced to be tied to the land. But let's deal with this. And again, if there were a legal wrong, it would not be a wrong to any living person unless they were somehow the authorized representatives to bring suit on behalf of their enslaved ancestors. What do y'all think about that? Comments? Does that destroy
You're dumb. No, it doesn't.
reparations in federal court? Press one.
No.
I got 12 people on here.
Yeah, exactly. Only 12.
Maybe 11.
12 idiots. Yeah, one dropped off because you're dumb.
What people are doing with you on social media, right, is what they're doing with you is that they are using words like reparations to get into your emotions, but they haven't read the case. And if they read the case, they would know that if there were
Hold on. Screen froze.
was a legal wrong, it would not be a wrong to any living person unless they were somehow the authorized representative to bring suits on behalf of their enslaved ancestors. Thank y'all so much. Now he says, with some exceptions to be noted, the plaintiffs are suing redress harms to third parties.
He's just exposing how dumb he is on this subject. And people got a nerve to say he's a scholar. A scholar in what? If he's a scholar, then I'm a triple OG scholar.
So our ancestors are third parties.
And if he's a scholar, then so is my chat. Because we know way more than this fool. And for the record, he's not a scholar.
Without being authorized to sue on behalf of those parties. So my great-great-grandfather,
We already
my
debunked that.
great-great-great-grandmother did not authorize me My
They don't need to. We already debunked that. That's already debunked.
family did not authorize me. My family will fight against me, some of our families, because they don't think maybe I should be the plaintiff. Maybe they should be plaintiff. They want to know how much money they're going to get if we win, right? We're going to have infighting on authorization, right? Right? Like we do with family lines when there are states and we have uncles that get the land and they get a deal from a realtor and they sell the land on behalf of the family and don't give the rest of the family anything. That has happened over and over again. An aunt, an uncle, right, that was closest to our grandparents, somehow they're able to get on the deed of the land and they sell it for their own selves. That has happened to my family and me and my family so many times. Right?
Brother, you can cosplay all you
So,
want, but
but
it ain't
in
gonna
this
happen.
case, the last reparations case, with some exceptions to be noted, the plaintiffs are suing redress harms to third parties, their ancestors, without being authorized to sue on behalf of those parties. It is like a suit by a descendant of a Union soldier killed in battle against a Civil War era gun manufacturer still in business that sold guns to the Confederacy in violation of federal law. A federal court could not entertain the suit because the plaintiff will be unable to prove a harm to an interest of his, such as a bank account that the law protects. The law is not going to protect your bank account, right? You can't sue on behalf of your family member that was a Union soldier that was killed by a gun manufacturer that sold to the Confederate Army. This is how they're playing with us. It is possible that had the ancestor not died when he did, he would have become a wealthy person and left bequests so immense that his remote descendant, the plaintiff, would have inherited more money from his parents or grandparents than he actually did. But this is too speculative an inquiry to provide a basis for a federal suit. Game over. Game over, right? So then, the two cases just cited and others treat remoteness as a limitation on Article 3 standing. Still, other cases treat it as a non-jurisdictional limitation on who may sue in federal court, but still a limitation. A family, the burdens of a federal lawsuit against slavery is immense. Anybody using reparations in federal court right now after this case is purposely doing it, right, to get to your emotions. Reparations in federal court is formally dead. I've written an article, Reparations is Dead, How to Resurrect It, in print with Dr. Jahi Issa. I have known this for many, many years. The article, Reparations in federal court is for your emotions. Reparations in federal court is formally dead. I've written an article, Reparations is Dead, How to Resurrect It, in print with Dr. Jahi Issa. I have known this for many, many years, and I laugh at these people talking about reparations. Now, when I will give it to ADOS, because they was talking legislatively, right? She was trying to talk to Warren and some other people. So she wanted, Yvette and Tone wanted, they wanted legislation, right? The other groups of people, it's still open as to, and confusing, what are they talking about? Tone is a lawyer. Tone read this case, so Tone knows. So he said he understood the political question burden.
Yeah, but let me guess. You don't know much as this crazy Libyan guy.
Right? And so he went legislatively, right? But here's the funny part. If you're doing social media, signal boosting, you would do something to get to the legislators. So you would identify the legislators, right, that needed to be talked to, and you identify to them what needs to be talked about. But just using the plight of our ancestors to emotionally charge people and get into this infighting on whether or not these Tezers or whatever you want to call them deserve reparations is a nothing burger. Is a nothing burger.
All of this is because we didn't include tethers. That's what all this is for. Since tethers are not eligible, then nobody should be eligible. Right? These are some one for all. If not one, if not just if it's not for FBAs, then it ain't for nobody. And if it's about FBAs, it should be for all. Like that. That's these crazy Pan-Africanists.
Right? So now, so the court continues. The court continues, but okay. In a hypothetical case of the Union soldier, the litigant with the paramount interest in the case would be his estate, and the damages the estate could recover would include whatever amount of money he would have wanted his descendants to inherit. If the descendant could sue the tortfeasor directly for that amount or for the tortfeasor's profit in a suit for restitution, there would be either double recovery or an impossible task of allocating the monetary recovery between the descendants and the estate. Okay, so then a few of the plaintiff's claims, however, as we noted at the outset, are claims of.
All right. Okay. Get back to this Libyan Muslim guy. He said a lot. But again, he just repeated the claim from earlier that the courts have already said a wrong to our ancestors is not a wrong to us, right? So that's kind of like the white supremacist conservative approach. Hey, but it didn't happen to you. You know, they argue the same thing. And that's how desperate they are. They're so desperate that they will line themselves up with white supremacists, but we're not surprised because their first leader, their first grand leader, their first grand leader had linked up with the grand wizard of the KKK. So we're not really surprised how low they would go to try to undermine our reparations stance, our claim. Okay. What is this? Yeah, so he's rambling, he's ranting, a bunch of nothing. It sounds good when he's by himself. When challenged, everything just falls apart. Tether babbling, tether whining, splaining, all that. It wrong. I mean, does that even sound like it could be halfway true? A wrong to our ancestors is not a wrong to us. Oh my God. I looked out the window and I seen a transitioner. Oh my God. Oh, those they be a little dangerous. Let me not look that way at all. But he's judging me. Yeah, so repeating a lie, and he's hoping this is what he's hoping for. He's hoping for this video to take off, like some tethers or the new Charlie Kirk replacement to take this video, research it, and repeat it amongst a larger audience. That's what he's hoping for. That's what mostly all of them hoping for. But I told you guys, I told you guys, I said the diaspora in Africa, when they come over here, their preconceived thoughts that they got inherited by their parents has already programmed them to embrace white racist conservatism. That's why it don't take much for them to join conservatism. I showed a video of that young Tether, Dominican chick. She claims she's a liberal but it never felt right. She was defending victimhood, and now she's alt-right right now. She's 100% alt-right. She's Dominican, she's kind of brown skin, and she had the nerve to call herself black, a black woman. That's why we gotta take that word back. And I cannot let them hold that. You cannot hold on to black. Okay. Then later on, I'm gonna do a live on debunking, fact checking. The same way I'm doing it, this Libyan guy, I'm gonna do another live, doing the same thing to Jared Teller when he debated Tariq Nasheed. This is gonna be good. You wait to hear how much he lied and misquoted data and information, as often almost everything he said was a lie. It's crazy. We're not surprised, but when you actually got it, in your hand, you're like, damn. Like, you guys, no wonder you guys are so insecure. You got a lie to kick it. Okay. So again, this tether says, courts already said a wrong to the ancestors, not a wrong to us. Don't know where we got that from, but obviously that's a false. That's false. All right. This is a false claim. Right. This is false. It's very, very false if the harm is ongoing and passed through generations, e.g., denied wealth, housing, health access, capital. So is the harm going on? It's like a RICO. You build a RICO when that person is still committing crime. If that person stopped doing his evil 15, 20 years ago, it's not really a RICO. He has to currently be, or that organization got to currently be involved in that said crime. All right, so check this out. In Shelley versus Kramer, 1948, the courts acknowledge how discriminatory practices in real estate harm future generations. So not just the people who were harmed and are passed away, tether, future generations. The Tuskegee syphilis settlement, Native American boarding schools, and Holocaust reparations all accepted harms to descendants when linked to specific policies. Oh, so the wrong to their ancestors was indeed a wrong to the descendants. That's why we just let tethers talk and then we cook them. Okay. So let them talk some more.
Subjection to involuntary servitude after it was outlawed by the 13th Amendment and indeed in the 20th century. Now, so that the plaintiffs put this in the case as a test, right? Kane Wall Sr. claims that during the time that he was enslaved, which he contends extended into the 1960s. So one of the plaintiffs is smart, Kane Wall. He said that he still was enslaved, and he contends it up until the 1960s, right? So now that's real great. He contended that he is still enslaved. One or more of the defendants were doing business in Mississippi or Louisiana, right? Some of the defendants had to reason to know of the enslavement of Kane Wall, and yet failed to take steps to eliminate the same, while they continue to inure benefits from the illegal but sanctioned system of servitude post-emancipation. But there is no claim that the defendants subjected Wall or any other class member to involuntary servitude or did anything to perpetuate or exacerbate his condition. The claim is that they took no steps to free him. The briefs suggest no basis for thinking that there's any kind of good Samaritan legal duty to eliminate a violation of the 13th Amendment committed by someone else. See, the law is very, very interesting. Okay. These judges will poke holes into even reasonable conversations without hundreds of affidavits and briefs, right? They will seize. Remember, you have a right to an attorney, right? Anything you say or can be held against you in a court of law. Well, in this particular case, what he said in his brief, they poked holes to it, right? Okay.
Family, this is a warning. He's going to trigger you. He's about to say some stupid stuff.
The limitation that Article 3 places on the right to sue in federal court
More stupid than what he already has stated.
Requires us to affirm through striking with prejudice on the basis of lack of standing. Black people, you cannot sue for your ancestors unless you have control over their estates. And even when you do that, right, then there's statute of limitations. And even when you do that, right, you have to identify exactly how that ancestor was wronged. And this is what the court is saying. First, although most of the plaintiffs and class members are suing as their descendants rather than as representatives of their ancestors' estates authorized to sue on those ancestors' behalf, a few do claim to be suing in such a representative capacity. It is highly unlikely that the estate of anyone who died a century or more ago, or indeed more than a half a century ago, for although many former slaves survived into the 21st century, very few would still have been alive 50 years ago, which is to say 1956, 91 years after the end of the Civil War, has not yet been closed. But the district court judge accepted the purported representatives. Now you're the damn purported representatives, right? But the district court judge did accept you, right? To embarrass you later, right? But the district court accepted that the purported representatives had a right to sue on behalf of their ancestors, and the defendants offer only a perfunctory rebuttal, right? So the defendants didn't even rebuttal that. They say, you know what, we'll do it later, right? Because we will find judges that will help us. So we don't have to fight it all now. We'll spend some money, and they were corporations and they had the money to spend. But we shall assume without deciding that some of the plaintiffs are legal representations of their slave ancestors, right? So we shall assume without deciding yet that some of the plaintiffs are legal representatives of their slave ancestors. These plaintiffs do not only escape the objection to standing that the suit seeks damages for injuries actually suffered by third-party ancestors, no longer third-party ancestors, but the real parties in the interest, merely represented by the plaintiffs, but have less to prove. They just have to prove the injury to their ancestors. The trickle-down question is eluded. So the court now is basically saying, let me play with you. I'm gonna play with you. I know that you don't have any standing in court, and I'm gonna get that later, right? I'm gonna get to that later, right? Now prove the direct injury to your ancestors. Now this is where we completely fall apart. Yeah, but we were just enslaved. It was forced labor, right? And it was ill-gotten gains, and we didn't get anything, and we lost our property, right? And the court is saying, okay, fine. Now you show the particulars, Show the particulars. Don't talk about all of our people. If your grandparent is Jenny Mabry, right? If the great grandparent that you're talking about is Jenny Mabry, right? I'm gonna play with you. I'm gonna let you be the fake legal representative for a while. But now tell me how Jenny Mabry, who is my actual grandfather's on my father's side mother, Jenny Mabry, who was not married to so my grandfather was born out of wedlock, and the her companion, right, Pender, right, that was his name, right. The court wants me to show particularly how Jenny Mabry, who was a sharecropper, who I know that she died on a sharecropping
Now
on
here it
a
is.
farm during.
Look. So now look at this statement you're gonna say about sharecroppers. It's so disgusting.
The swine. The court wants me to show particularly how Jenny Mabry, who was a sharecropper, who I know that she died on a sharecropping on a farm during the swine flu period, but the court would say that, and she died of exhaustion. She died of exhaustion, Jenny Mabry, my great great grandmother. Uh, but the court will say, well, Mabry, she died of swine flu. She died of exhaustion on a plantation that she was sharecropping on, and but her cause of death was through swine flu. So, Mr. Mabry, why are you in our court? Well, she was sharecropping. Okay, she was sharecropping. That's fine. You have to list the defendants, the plantation owners of Jenny Mabry to proceed, right? You will have to. Well, all I have is a death certificate that says that she died. But Mr. Mabry, you're not producing the particulars. You have to tell me how long they worked. My great grandmother was a migratory sharecropper. She worked on different farms, right? The truck would come, and the truck would pick you up, and the truck would take you to farms, and you be in a farm for a season. That's just how sharecropping worked in the parts of North Carolina where I'm from. So I don't know how many seasons she worked for that sharecropper because I only have a death certificate. So well, they'll say, well, Mr. Mabry, if you find that sharecropper, well, you're gonna have to show me how long she worked for that sharecropper, right? And you're gonna have to show me some payment. It's insurmountable burden that I would have to pursue for.
Oh my God, he's acting like our reparations claim would be so difficult to prove, so hard. Don't even try, just give up. Foundation of Black Americans, just give up. It's so hard. But let him argue on our behalf and collect the money in our absence. This guy is a clown.
For my great great grandmother Jenny Mabry to get anything. Okay, so the court now slams this case. In all likelihood, it would be impossible for them to provide injury.
So he said it would be impossible. Okay, to provide injury. Okay.
That's what I'm talking about. Requiring it so that would connect the particular slavery transactions in which defendants were involved to harm the particular slaves. But in any event, suits complaining about injuries that occurred more than a century and a half ago have been barred for a long time by the applicable state statutes of limitation. It is true that tolling doctrines can extend the time to sue well beyond the period of limitations, but not to a century and more beyond. Slaves could not sue, and even after the 13th Amendment became effective in 1865, suits such as these, if brought in the South, would have not received a fair hearing. So the court is laughing at us. Well, the slaves couldn't sue, and even after slavery, they still couldn't sue because of the climate of the black codes and Reconstruction, right? They're laughing at us. However, some northern courts could have been receptive to such suits, and such the defendants are and were northern companies. Venue would have been proper in those states. Even in the South, descendants of—
So family, remember I said this whole thing is about procedures, and their procedural has nothing to do with what they're prohibiting. He's acting like we're getting blocked just because we're getting blocked. Okay, this is a fool. Watch.
slaves have had decades of effective access to the courts to seek redress for the wrongs of which they complain, and if not, as if it had been a deep mystery that corporations were involved in the operation of slave system. The second qualification concerns the claim rather buried in the complaint, but not forfeited, that in violation of state fraud or consumer protection laws, give me 1 second.
Yeah, while we give you that 1 second. Okay, so he claimed that even people who claimed harm into the 1960s, which he gave the hypothetical or realistic sharecropping example, I'm not sure, but he said they couldn't name the employer, or they couldn't prove injury or prove payment. Good job. So he was claiming that was grounds for rejection, right? But here's the truth. The truth is that the court didn't reject the concept. They rejected the lack of documentation. It's procedural. That's not a legal bar to reparations. It's a call for better record keeping. So somebody didn't have good record keeping. This is where state commissions like California's task force and proposed federal HR 40 style investigations are essential to document and create standing. This is a fool. So now lawsuits are just one route. But by this fool's logic, all other reparation movements, Japanese, Jewish, Native, should have failed too. They didn't. So based upon what he's saying, the Japanese got reparations illegally, Jewish people got reparations illegally, and Native people got reparations illegally. Like, this is a fool. The Supreme Court has never ruled that reparations for slavery are unconstitutional. He just made that up. State and local reparations, Evanston, Illinois, California task force are moving ahead, showing that legislative and administrative pathways are alive and valid. Now, he said FBA is just a copyright, not a real lineage. Ethonyms evolve. African American was also coined by Jesse Jackson. Naming doesn't invalidate the group's legitimacy. Okay. He said, you don't know your ancestors, you're doing it all wrong legally. Oh, that's true for most Americans. The census didn't even record names for enslaved people until 1870. That doesn't erase the fact that over 90% of Foundation Black Americans today descend from U.S. slavery. Okay. Then you got to advise constructively. Don't gatekeep access to justice, which he's trying to do. Many legal efforts begin wrong and evolve. So if we're wrong in one place or another, that's okay. A lot of legal efforts begin like that, but they evolve. You figure out what's right and you do it over, Okay, so FBA, we are mobilizing popular pressure and awareness. That's the first stage of political success. All right, so he wanted to be perfect the first round. Guy's nuts. All right, all right. Okay, so I want to pull up something he said that made me go research it. Hold on. Oh, damn, tether. So I think this is his twin brother right here, Gaddafi. Yeah, I think that's his long lost son, his descendant, somebody. Look like twins, yo. Look like straight up twins. Hating on us. Hating on us.
Wrote called Reparations is Dead. Where is it? Give me a second. It should be coming up. Oh, here it goes. Okay, great. So this article I wrote called Reparations is Dead, How to Resurrect It. I wrote.
By the way, can't find this article anywhere. I just searched the net up and down, up and down, up and down. Where is this article, man? What's that? IBW. Wait, let me see. I can't find this nowhere. IBW21.org. I'm gonna find this article. Okay. Let me see. Let me see. Reparation. I'm at the website. Today. I gotta see if it pulls up. Oh, okay. I found it. It's a blog post. This guy's a liar, man. An article. They'll try anything to sabotage our reparation movement. But at the same time, they'll claim we're not going to get it, or it's a nothing burger. If that's true, then why are you trying to sabotage it?
Wrote it in 2017. Okay, great. So this article I wrote called Reparations is Dead, How to Resurrect It. I wrote it in 2017. So this is years after I testified at the city council. And I wrote this article with Dr. Jahi Issa. And what we had found is that there are other strategies to reparations. And the first opening of the article is the moral case for black reparations has effectively been made. Stop. But the legal argument has met much frustration in the courts. Stop. The authors believe that the period after 1808, when U.S. participation in the international slave trade was outlawed, is key to clearing the legal hurdles to reparations.
So keep in mind, his claim is that FBA is not a legal term. FBA has no historical precedent and will be struck down in court under Rule 12b-6. Clown.
So this was one of our strategies to talk about the illegal slave trade, and help people understand what the problems is in countering the legal slave trade, and then to look for other options, which we found in what we call local reparations. So I'm not saying my particular audience, but I'm just saying in the community, these people want to listen to people who never testified on reparations, never chosen, never took formal Black studies or African studies, never did that.
Oh, nah, I ain't never do that, and I never will. Definitely not doing that. Then I become a liar like you.
Popped up in 2019 after all the great work has been done, and want to rename our people with names that you cannot find in history. You cannot find them in law. These terms have no basis in law. And so do you know what happens when you start bringing up terms that have no basis in law, that there's not written? The courts will strike it with a 12b6 motion to dismiss as conclusory. You may feel that
This is a stupid nut job, yo. Stupid nut job.
you are saying something smart, but there's no basis in history and there's no basis in law. And so if you do not know about law, you should not be talking about reparations, because what you're going to do is the courts will seize on your bad thinking and render further case law. Now, we have seen this happen, unfortunately, with a lot of the Moorish cases, right? Now, because so many of them have been put up using bad law, they have become frivolous. So if you are trying to represent yourself as a Moor and you try to apply to pauper status, you won't get it. You will not get it. You have to pay the full price. Second, after you pay the full price and you go through it will be dismissed early on the 12b6 motion to dismiss, failure to state a claim, because you would have to show that you are in fact what you are representing, and then you will have to show documents relating to the fact that you have some historical connection to these groups. So then,
all right, so legal standing does not require that an identity label must already exist in statutory law. So he just made that up, saying we can't use FBA. He said legal standing, he's just stupid. Legal standing does not require that an identity label must already exist in statutory law. Groups like Native Americans, Hispanic, and the LGBTQIA+ were not codified terms before movements made them politically and legally relevant. The legal argument centers on standing and harm, not terminology. Courts ask, where are you harmed and can you prove it? Not your name. FBA is not being proposed as a legal term, but a lineage designation to narrowly define the injured party for redress, the same way other group-specific remedies work, e.g. Japanese internment victims and Cobell case for Native Americans. Stupid.
and what the courts will do, unfortunately, as they have, is make things frivolous. What would be harmful to us is to make our reparations issues frivolous. We're going to talk more about this maybe tonight or on a follow-up show. Bad thinking produces terrible, hideous attacks by legal courts that prevent any further discussion on what you think you might be talking about. So ADOS took another course of action. Why? Because they are smart. They are trying to, it does not trickle down to us, right? But, instead of giving it to them. Unfortunately, they didn't write one for Congress. So now you're asking a congressperson to write something, whether instead of giving it to them. Then they sought out Sandy Doherty to estimate the value of a claim, right? But again, unfortunately, the claim goes to the ancestors. It does not trickle down to us, right? But nevertheless, a new bill was not rendered, and so it becomes talking points. This new group, Foundational Black Americans, they've created a new term to describe our people that's not in law, that's not in history, is conclusory, and their issue is that we have to separate ourselves. We have to delineate ourselves. The foundational Black Americans have to delineate themselves from other Black people who were not enslaved. What they do not understand is that the new reparations movement has as a backdrop American slavery, but deals with current situations that are derived from that. So it's two parts. I have some strategies that I would like to talk about to fix the burdens that the courts have set for us. Why? Because I've studied the case law. I not only study history, I study case law. So I've studied the case law and have studied a very important attorney that we have lost, Attorney Ogletree's comments on reparations, which he gives the best. But nevertheless, reparations have, the new course is local reparations. So in local reparations, they look at the citizens, the living citizens of their current city, county, and state. And so the living relatives, the living people in their cities, counties, and states, that is who they're concerned about. They're not concerned about as much deceased ancestors, but the effects of that on us, right? Who would be plaintiffs, but the new course is not to go back into the courts. The new strategy is to go into legislation, to have majority Black cities and counties who have city and county governments to create legislation that benefits people who have been harmed, not by slavery, but by the ill effects of actions against us. Things like the Black codes that led into the Jim Crow period, right? Into things like housing discrimination and all other types of discrimination as a result of the treatment of people because they are harmed because of their phenotypes, not just skin color, but their phenotypes. The problem with these new groups called the FBAs and these other groups of people, they want it lineage-based. So, but they're not smart enough to understand that cities and counties are only dealing with people who can vote for them, living people. And so they feel that any reparations should be done by people who can track themselves to slavery. Unfortunately, because of the federal law, cities and counties have to be very cautious because the same law, the same opinion by Posner in the federal case of the reparations will follow them and find whatever cities and counties do in that regard, they will find it unconstitutional. So these concepts that are arguments that these groups of people are in fact raising are actually frivolous. They're just talking points. They're not going to do the work. They haven't been doing the work. They have been signal boosting. That's a social media term, but they haven't been doing the work. Of course, the best of them is Yvette Carnell, Tone, and Tariq Nasheed. The people, some of the people underneath them are really well uninformed, right? At some point, I will have a conversation with Tariq Nasheed, and I have a good relationship with him. But there are some issues that I think that he needs to answer for, or answer, not answer for because he hasn't done anything wrong, but answer the question, the delineation of Black people based on what you call lineage is problematic for a number of reasons, right? One is because of the federal opinion. The other issue is that many other Black groups have moved into America, and we need them for votes in legislation. And so New York City, the same New York City that I testified in, has passed a reparations study to study effects of discrimination based on phenotypes and resulting from the enslavement of New Yorkers. How it was passed, it's interesting that many of the people who voted, not many of them, but a large population, were leaders, city council members, leaders who were never enslaved in America. They're not descendants of people enslaved in America. They are Caribbean. And they voted for the study of reparations. All these groups of people can say is that they were on code. This on code word is a problem. They are doing what is right, what is legally sound, which is historical, right? And knowing full well that if they discriminate in any other way, it will go to the Supreme Court. There will be a case in federal court striking their reparations. It will be appealed by the city, and then it will go to the Supreme Court. And if we don't do it right, then the equal protection law will destroy any gains. Now, being wrong on YouTube is one thing. Being wrong in courts, that's a whole nother thing, right? So the people who really are dealing with reparations, because it's already going on, for example, in Evanston, Illinois, they went past the study they actually began to give out reparations to one generation. And they gave $25,000 to lots of senior citizens, right? Just $25,000, nothing. But yet 5 plaintiffs in a conservative organization dragged them into court. So the city of Evanston is fighting these new plaintiffs based on that whatever you're doing for just Black people violates the Equal Protection Clause. So when you start looking at law and you start looking at all these conclusory labels that we put on, another one is freedmen. Freedmen is an act. Freedmen is a term from an act called the Freedmen's Bureau Act, which gave a status of people, formerly enslaved people. That's what they called them, that status, formerly enslaved people. The freedmen of the South, not all Black people again, not all of our people, just the freedmen, and it was basically a welfare organization. And that Freedmen Bureau was largely staffed by white people of that time period, who themselves did some good things like use the money to create schools, which we badly needed in the South. But at the same time, many of them helped disenfranchise Blacks because they were supposed to be representing African people, Black people, on land disputes, and very few of that was successful. But the education part of it was. But the problem with the Freedmen's Bureau is that it didn't largely, except for building schools, impact the group of Africans that were already freed before the Civil War. So those are Blacks in from, let's say, Delaware and above, that were already freed before the Civil War. So it was only to help those enslaved Blacks that were liberated during the Emancipation Proclamation, and to shelter, to give them food, to give them housing, and some education and some other benefits. That is not a status that you take to court. What the status could be revived, but you have to create another bureau. In local, not in the federal government, because that's never going to happen. Not in Congress and not in the Senate. There are pockets of advocates in some cities and counties that want to create what you call a Freedmen's Bureau. But again, the whole context of Freedmen Bureau is kind of like an organization that gives services and things like that, but not money, not land payouts, none of that, just money. So tonight, let's see, we are going to be discussing Callie House. We're going to be discussing the term African American. We're going to be discussing the legal case, the Deirdre Farmer Pellman case that was dismissed in the appellate court. We're going to be talking about many of the contradictions. We're going to be talking about many of the contradictions and why people are, yeah. So now I just finally, because I got a new thing, a new streaming service. So let me just see some people that were on. Let me just go to the full page, the YouTube page, so I can see and thank the people who are coming in and take a look at some of their what they have said. So let's just see. Give me a second to see my chat. Okay, and hopefully I could pay attention to some of the things that people have said. Okay. Okay, so it's always somebody in the chat that wants to call me a name, right? But show me your education. Why is this not showing up? Show me your education. So let's see this chat. Sorry, I might be frozen. Okay, so show me your education. Show me your mother and father's education. Show me. Okay, so this is on. Okay, so it's not this one. Let me see, Brother Reggie. This test, it should be here. Okay, great. I have some audience and I did not check. Brother Law, thanks so much for being the first one. Silent K, my brother, Silent K, how you doing, bro? Peace to you. Thank you for joining. Who else is on? Sorry. Okay, Super Wavy, fly his name on YouTube. How you doing, good brother? Who else is on? Proper Perspective, and peace to you. Let's see what's going on. Mr. Morpheus, finally got a notification. Peace, Reg. Peace to you, my good teacher and brother, friend, Brother Morpheus, a real hip hop pioneer. Not the first wave, but definitely the second wave. But he was there when it was actually happening, right? He's part of the Herculoids, right? Son Ka, peace, Saber. How you doing? Yeah, Son Ka. Yeah, Saber in the building to you. So, Mr. Morpheus says, lawsuits filed in 2002 seeking reparations for slavery were dismissed by federal courts. Definitely, that's 2007. Federal court caseload statistics generally focus on criminal, civil, and bankruptcy case. That's correct. Sister Mika, how are you today? Peace. And another fly name on YouTube, Tony Macaroni. You can't get no fly than Super Wavy and Tony Macaroni. Peace to you. Solomonic TV, is there a link for this show? I will put in a link in a second, and I will discuss. But tonight, I'm going to give you the history of reparations. And guess what, family? It was started by a Black woman. And I don't know why many of these Black men want to erase that fact, but it was started by a Black woman. And it was her work and her membership that was absorbed by the Garvey movement. Okay, so let me get rid of some of these things that's on here so that I could open up a chat. There you go. And here you go. So I'm back to live. So now I am going to invite the guest studio. And here it goes. You are invited. I have a small channel now, as many of you know. I'm now presenting on my own show, which is Africa Online, and I am presenting on shows that I choose that I want to participate in. I'm no longer where I was, and I'll just leave it like that. But I can still get out the information because I have some of the best information. So I've heard that many of the people or some influential people on some other channels said that I'm boring, I talk too long, I talk too long, and I hold people hostage for cash apps. Well, my comment to that is I'm not doing anything that I haven't been doing for years, which is to teach. I do not have to interview people who I may disagree with. for clicks and giggles. Two, it has to be a benefit to me. If there's no benefit to me as far as monetary, even for lunch money, right? There's no benefit for me. So now if you are saying that, if people are saying that they're giving me exposure, thank you so very much. I don't need the exposure anymore. If your payment to me is exposure, I don't need your exposure no more. So now that I brought us into relationships and friendships, right? And given that in some of the other channels I have done the most for, right, in the hardest of times. But if that is the price to pay, I'm not willing to pay the price, and I'm not going to be beefing. I'm not going to be arguing. As far as I'm concerned, as far as the information is concerned, I have great information. But if you want to hold my information hostage, that's fine. That's fine. But at the end of history, we'll remember Brother Reggie. And nobody created Brother Reggie except for Dr. Leonard Jeffries, Dr. John Henry Clark, my parents, right? Professor Edward Scobie, the Black Studies Department at City College. They created me, right? YouTube did not create me. I had a YouTube channel before majority of the people had YouTube. So YouTube did not create me. I brought my content on YouTube. So let's get that straight. And I have a lot to say. I have a lot of animosity. I have a lot of animosity that I have to stop myself from talking about, right? About how people treat people. But I won't say it, because then it's going to get personal and it's going to start talking about other things instead of information. But the fact of the matter is, nobody but Dr. Leonard Jeffries and Professor Edward Scobie, Dr. John Henry Clark, and Dr. Yosef Benjo Cannon created me intellectually. None of them. Exposing me to a population, that is another story, but my exposure debt is paid. So if I have to suffer with 120 views, 150 views, I'll take that, because guess what? I know that at least I'm putting out the information and I don't have to argue with people who, why am I going to argue with somebody who hasn't had the experiences than me? I went to Africa in 86. West Africa in 86 with Dr. Clark. I went to Kemet in 87 with 1,000 people. Where were y'all? The people that have so much to say, what were you doing in 86 and 87? In 2002, almost damn near 10, 20 years late, 15 years later, I'm testifying in the reparations. Where were you? But if you think that the price of holding my content hostage, right, is something that you feel good about, right, then that's fine. That's what you feel. So I would never try to make it more than what it is. But if you look at my shows, all of my shows, they're cited, they're sourced. I'm not a makeup artist. But if you people here value entertainment, you're not going to get it from me. You didn't get it from my teachers, right? I don't have to do jokes. I have to do facts. But if you people value that, then fine. But I know this for sure. This is what I do know. Values that and disvalue strategies that can help us. And value talking points that will hurt us. Because this is YouTube. Now the greatest show on earth. Circus of people who want to people who want to sell themselves but not really help Black people. I have a history of helping African people, African descendants, Black people, So those people who come on my show, I appreciate you, right? But I tell you one thing. Some of the doors that I go through, I would have to check you in or leave you in a hallway and say, I'll be right back, or say you my guest, right? Because you're not relevant. You're really not relevant. You can come in with your costumes at the door. You'll be sitting in the waiting room, right? You won't go there, right? So, matter of fact, in federal court and places like that, you wouldn't even know when the cases are going on. You wouldn't even know how to go to the court part, right? You know why I know? Because I've been there and didn't see you. All the reparations meetings and stuff, I ain't see you. I ain't see you there. And meeting that happened 15, 20 years ago when you was on the streets doing what you do on the streets. Now you want to recreate yourself and be a person that says that you love Black people, right? But 20 years ago, I was testifying for reparations, and another 15, 20 years ago, before that, I was studying with the greats, walking with the greats. So here's you want to chatty patty me? Here you go, you are invited. I'm not talking about necessarily Solomon TV. I'm just talking to I'm just talking to the people who got lots of stuff to say with no grounds. So I really want to smoke. I don't want the good people. I want to smoke. So come up here and show me what gang you part of. What conclusionary gang that you're part of. Come on. Come on. Show me when you get started in this. Show me your education. Show me who your mentors are, because it's those that I really want to talk to. I want to talk to your mentors. Find out how good of a student you were. Huh? So, but the most important thing is tonight, on Unscrambled Minds, I'll be talking to their audience about reparations. Hi, Reggie. I see Inky that he got you beat on the tweezers part of the Kemet surgery. Please address him in detail. See, let me, since he puts a person on the chat. So tweezers in bronze says that they was doing open heart surgery. And you believe that he got me beat, that they were doing open heart surgery when tweezers first appeared, open heart surgery to look at the aorta. People like you, right? I feel sorry for you. I feel sorry for you. That shows you know nothing about medicine. You know nothing about antiseptics. You know nothing about medical technology. Show me your own work instead of being a groupie. Right? There is no scholar that studies the subject that agrees with him. My big little brother, Dr. Mario Beatty, addressed that. But you missed it because you're a groupie. Right? Men, why don't you stop being groupie? Be grown men. Stand on your own information. Sister, stop following these people. If a man can't show his own information and wants to have a homo association with another man, sister, those type of men are not for you. Right? If they don't have their own work in the field and they are doing YouTube stuff, being a fan, right? Without their own information, they're not standing on their information. They are a groupie. They're a son. and sisters, you started reparations. You started a lot of sciences, mathematics. You did that. But yet you are held down by these type of men that are in competition with you, that have done less than you. Now, I'm not talking about all men, of course. I'm talking about the ones, the preachers, the pimps, the politicians, those, sometimes even the professors, right? Those groups of men that want to basically borrow not just your own information, but other people's information, because they didn't think about it. They don't have the ability to think about it, and they want to kind of still keep you under them to promote themselves. So I feel sorry for the person who wants to talk about, while I'm talking about reparations, he wants to talk about tweezers in Egypt. And I do not have to talk to the same thing I would say to him and some of these people that they're talking about me. Show me that you passed the Europeans test. That's what I say, because I have. I'm a former engineer, former practicing engineer. I have a degree. I passed that test. It's easy to get in front of black people and say what you coulda, woulda, shoulda did, but show me you passed the test. Show me degrees and work experience. I want to know where you worked at after you got your degree in your field. Yeah, that's what I want to know. But I do know that many people on YouTube, they don't value that. They value hot takes and smart mouths. Pan-African Designs and Apparel. What's up? What's up, good brother? I am just doing I'm just doing a conversation on reparations that I'll do a fuller conversation tonight. It's just a promo to that show, because I'm going to be on that show, and I'll be on, as you know, I'm on Smash Rockwell show. I go on Onks Media, right? Community of Skeptics, and I go on the other shows that he puts on. I go on Carnivorous podcast. I like Sheffrin. I like Sheffrin's idea. I like the way his mind works. I tried to go on. I go on All Viral Access Media because he has good urban topics, right? And there was another channel that I thought that I could help, but the person seems to be a part of the gang of FBA. And when I told him about the term African American, and it was a term that an African American created, he says, how do we know he's black when the person says that he is an African? And then once you do that to me, once I show you the information, and then you come up with another bogus conversation like, how do we know that this person is black or African? Because I defeated you, your argument, and then you want to persist, I can't be a part of what you do. And so Unscrambled Minds, I've been on their show several times, and so I'll be on reparations tonight, 9 o'clock. Super Wavy, stay focused. It's a long fight. I am focused, Super Wavy, on the fact that there are people who are giving out people bad information. So giving our people good information and not addressing those people giving out people bad or incomplete information means that is that I don't show the dichotomy. I don't show the dialectics. I don't try to convince the people to look for good information or to do it themselves. So I do apologize, but I am doing it somewhat professionally. Why? Because I put in a link, right, for all the smoke. So I'm not just talking. And if they don't want to talk, they're scared, as they say, because all they're going to do is regurgitate who their homo association friend is. And homo association is not sexual. Homo association, it means male associations. People males that value what other males say without doing their own work. Groupies. Pan-African Designs. You need to have a fact check on your last show. Okay, I shouldn't have said that. I should have just read it. Super Wavy. He got one of the flyest names on YouTube, but Pan-African Designs is a fly name too. So there you go. So with that said, tonight, let me see, find Unscrambled Minds. Let's go find Unscrambled Minds and show you the show. So let me just see YouTube, Unscrambled Minds. Unscrambled Minds. Give me a second. It goes. So I'm hoping that some of you would like to know where reparations started. I would think that some of you would know the important reparations case and what it means. Just to have some fact checks. But tonight, live in 6 hours, January 24th at 9:00 p.m., Brother Reggie comes to discuss reparations on Unscrambled Minds. So there you go. So if you are not busy tonight at 9:00, please tap in and let me just see the last comments, if there's any. Super Wavy. Brother Charles, woke up to your voice, big bro. Your own channel is long overdue, especially when you put the well-known onto YouTube on the first place. So that is a fact. So where's the comments? Let's see if I can find a comment and blow it up. Yeah. This gets a blow up if I can. So there you go. Brother Charles, thanks so much. I appreciate it and listening to me instead of these copycats and regurgitationists and people that want a following but have no history. I appreciate that. And I appreciate the people that know that nobody made Brother Reggie. Maybe gave me some exposure, but they benefited from the exposure too. So at the end of the day, I want to thank everybody for coming out and viewing the show. And I'll see you tonight at 9:00, where I talk about an amazing woman, Callie House, to women, and because they're running the show, and to an audience. A woman that started reparations, a woman that started the first insurance business, a woman whose 300,000 petitions that we have records of got absorbed into the Garvey movement, which was non-FBA, as they call it, based.
Well, the Garvey movement is definitely a scam, so you can have that one.
The Garvey movement, and became the Garvey movement, and
That's a
talked
sham,
about a
scam.
little bit about Audrey Moore,
No, ma'am.
who you know is Queen Mother Moore, who continued the reparations movement, made it live kept it alive. And after her, there were several other women, but one standout is Dr. Blakely, who I've met many, many times.
All of these people are sham artists, scam artists, and Pan-African artists. Okay, so he likes to say FBA is not a legal term. It has no historical precedent and will be struck down in court under Rule 12b-6. Okay. He also says these terms have no basis in law. The courts will strike it down. As I pointed out earlier, legal standing does not require that an identity label must already exist in statutory law. He's just a clown. Again, I said groups like Native Americans, Hispanic, and LGBTQIA plus were not codified terms before movements made them politically and legally relevant, fool. So the legal argument centers on standing and harm. The legal argument centers on standing and harm, not terminology. Courts ask, were you harmed and can you prove it? Not what do you call yourself? FBA is not being proposed as a legal term, but a lineage designation to narrowly define the injured party for redress, the same way other group specific remedies work, e.g. Japanese internment victims, the Kobo case for Native Americans. Okay, so he claimed lineage-based reparations don't work legally or politically. He says cities and counties can only deal with living voters, not descendants. Local reparations are the only viable model. Local, okay, which we argue the opposite. We say federal. All right. So anyway, so he says cities and counties are only dealing with people who can vote for them. Lineage-based is not smart enough to understand that. So he's saying we're dumb. All right. But this ignores the fact that lineage-based eligibility is used in Evanston, California, AB 3121, and other local reparation proposals. Descendants of Holocaust victims, Japanese internment, and Native American land settlements all use genealogical tracing to determine eligibility. So he's a goddamn liar. The fact that living voters implement reparations doesn't mean that the beneficiaries must have been harmed in the last decade, fool. So he's trying to box reparations into only one viable local only strategy, ignoring HR 40, international law, and federal level remedies like the Civil Liberties Act of 1988. A fool. He says Foundation Black American is conclusionary, frivolous, and ahistorical, but he says African American is valid because Jesse Jackson popularized it. That's what he just cooked himself. Jesse Jackson's African American was not in law or history at that time. All right. It was a new cultural political label that was widely adopted, just like FBA is now, family. What makes an ethnonym valid is collective identity and usage, not whether it was in case law 50 years ago. He's a fool. This contradiction shows gatekeeping. He supports labels that emerged before 1988, but mocks new ones that reflect evolving political consciousness. Okay. He says reparations are only valid if they address contemporary harms, not slavery. He says local reparations should avoid mentioning slavery and focus on things like redlining, phenotype bias, etc. So he wants to anchor in tethers. He says they're not concerned with deceased ancestors, but the effects, things like black codes. All right. But here's what's going on. He's conceding. Listen to what I said earlier, family. He is conceding to white conservative legal fears by saying we shouldn't tie reparations to slavery. I told you, family, these fools are aligning themselves up with the Charlie Kirks. That's where they're going because Pan-Africanists failed. It flopped. He's downplaying the descendants of slavery. It remained impacted by wealth theft, land dispossession, and multi-generational economic exclusion. Okay, this erases the direct harm done to specific bloodlines, which undermines the strongest legal basis for reparations. He contradicts himself on strategy. Watch this. Speaking of contradictions, he says courts will dismiss lineage-based cases, but localities should create freedmen's bureaus, which will require legal standing and historical claims. A fool. He says freedman is a term, not a status you take to court. The freedman label is explicitly a lineage-based legal status tied to federal and state recognition. This is an idiot on the screen. If freedman status can be recognized locally, why not FBA or ADOS as updated identities for the same lineage of group? Fool. He's again gatekeeping. He prefers older bureaucratic models, even if they are toothless today. He uses credentials as a deflection. That's what he does. What school you went to? Only those with legal degrees or formal Black studies background should speak on reparations. Others are groupies, not serious or giving people dreams. They all do that. All of them do that. He says you may feel you're saying something smart, but you don't know about law. All right, so watch this. Movements are built by the masses, not just PhDs, Black Lives Matter, SNCC, the Panthers, the Garveyites, all grassroots driven. I don't see a whole bunch of PhDs in the Panthers, okay? His obsession with credentials show elitism and an inability to engage on substance. Courts have upheld pro se litigation and community-led advocacy countless times in civil rights law, e.g. Brown versus Board, started with NAACP lay organizing. He wants to appease multicultural policies. He says Black immigrants who didn't descend from American slavery still deserve reparations. I told you, family, these guys are agents. The holy FBA Codex was right. FBA delineation hurts us politically and loses the U.S. votes, he claims. But he wants to tie in tethers. That's all it's come down to. How can tethers benefit?
Who represented Queen Mother Moore. And Queen Mother Moore, many of you might have seen her at the first Million Man March because she was a spokesperson.
I'm gonna come back. I want to talk a little more.
At the first Million Man March, but many of you didn't go there. I'm not talking.
Oh, let me shout out Snatch super chat of $5. Lineage love. Thank you, family. I did see that earlier. I was trying to get back to you. This is a tether speaking. Gaddafi, the former president of Libya. Yeah. Thank you, Snatch Adam 69 for the super chat. Yeah, he's crashing out.
Talking about the people watching today. I'm talking about the people.
And I'm gonna also cook this right here. This is next. This garbage blog that he did, that's next.
With the big mouths. Salamic, I did put in the link. Do you see the link? I did put in a link. I think that you had something that you want to say before I close out. Yeah, okay. So if he doesn't come in the next 2 minutes, reparations as we know it, or which some people are, how can I say, signal boosting, is not the reparations that can be won. Separating yourself based on what you call lineage. Does your lineage only begin in enslavement? Does your lineage, whatever it means, only begin in slavery? Does it begin in Africa on these slave ships? Or does it only, watch this, y'all, come on, think with me. Does it only begin in the progress of white America? Because all that we have done in white America has been absorbed, has been absorbed by white industrialists. So running around talking about your achievements in Black America means what? they owe you, or does it mean they took it from us? And so you are tying yourself into the achievements of white America. And what are you talking about that we need to do for ourselves? So if you're arguing with me about reparations, right, a promise or something that you think that they owe us, it's war. Conquerors don't give nothing to the people that they conquered. You don't understand that? You're going to argue with me. You're going to delineate from other African people because they were not enslaved. So you know what you're saying? You're saying that over some money, you will separate from your brothers and sisters. Right? And you're going to keep it, you're not keeping it in a foundational Black American. No, that was, if anything, that was them that did the work. That's not you. You're not a foundational Black American. Your ancestors were. You're a citizen of the United States. You're governed by federal, state, county, and city
By the way,
laws.
this video got no
Who
views.
you fooling? Let me see a legal brief that you wrote. Let me see anything in law. Let me see your writing in general. Let me see a citation. Like, who the F are you fooling? I think you're taking advantage of your people. You people. I think you're taking advantage of people who is struggling in the United States to survive, who don't have the time, who occasionally can go on YouTube or Twitter or any of Instagram or any of these and look for a hot take because they're too busy trying to feed their family.
Right. So this Tether said earlier that he said we need immigrant Black groups for votes and legislation. We can't discriminate. I don't believe they vote in our best interest. Okay, but anyway, this is a political miscalculation. FBA, we're not discriminating. We're clarifying eligibility for a specific historical injustice, for a specific historical injustice. Jewish reparations don't go to all Semitic people. You get that? Japanese American redress didn't include Vietnamese. Reparations by lineage are standard. So his argument undermines the very idea of specificity because he want to tie in these goddamn tethers, which is but specificity is required to win a reparations case. So he wants to lose. We know that. So he minimizes new activists and claimed to be the gatekeeper, right? So he says new groups like FBA and ADOS are latecomers who didn't do the work. So he's the gatekeeper. He and his mentors testified 20 years ago. He talks about and deserves sole control over the conversation of reparations. I tell you, family, these guys are mad that they cannot be the leader. They're mad that they cannot be the leader because we accepted that the lineage is the leader, the code is the leader. That pisses them off, and it double pisses them off that Tariq Nasheed is stamped it. Said, yeah, that makes sense. And don't forget, they hate him. So they look at it like, damn, Tariq has stopped all of our hustles of being a leader. All these folks, this guy, Dr. Maya, Umar Johnson, Smash Rockwell, all these guys, the Mountain Dew guy that's obsessed with Tariq, all these guys want to be the leader. All these women want to be the leader. But the fact that we stand behind the code, which is the lineage is the leader, your birthright. We have a birthright citizenship within the lineage. And your birthright citizenship makes you a leader. You have a voice of a leader. You're born in the lineage. Your voice matters. Lineage voices matter. LVM and lineage voices matter. Okay, so he wants to gatekeep. What were you guys 20 years ago? No, you can't come now and take over. I'm the leader. That yeah, did A. Philip Randolph say that to Dr. King? Dr. King is uh noted as the leader of the civil rights movement, even though A. Philip Randolph is the grandfather, right? But he didn't say, nah, Dr. King, you come in 20, 30 years later. No, man, I'm the leader. Nope. He said, bro, you got the swag right now. You got the wave. You wavy. Let me just help mentor you. Let me let you get the keys, but let me just share how far I drove and the feats I tackled. Okay. This is what I've done. This is where I brought it to. And you could take that along your journey. He gave Dr. King the keys. He didn't hate. So this guy like, nah, these newcomers, his words, these newcomers are too new. They got to make me the leader because I did this, I did that. Stop it.
Families are too busy trying to survive or just coming out of incarceration, and you want to sell them a dream. Please don't sell them a dream of reparations. Reparations is going on very slowly without your help. Without your help. Without your help. And they don't ask you for your help because you mess it up. I heard something on one of these channels about how Black people who were not on code messed up the California reparations.
So before you go tether into that, so he asked, where were we in 2002 when he testified? So we can't criticize him. We can't, he has a all access pass because he testified in 2002. Testified on what?
Uh, California reparations. I heard that. So these people in California, they did the study on reparations. Now it came up to voting. They don't talk about the chief ally. I mean, the chief people against it was the governor Newsom, who is going to lose his job in California, in LA. He's going to lose his job, the governor, for the wildfires. So chickens come home to roost to you, right? But he was the leading adversary against reparations. But they want to blame it on Black people that's not on code. Wow. Didn't it dawn on them that some of the people who were against passing it felt that maybe our people wasn't going to benefit the most from it, and that there needed to be some rewording, right? Because at its current state, maybe it wasn't narrow, so they, our own people, voted against wording that would hurt us, rather than we not being on code, right? And wording is very important because if you don't word things right and on paper, which is permanent, it comes back to bite you. So maybe it wasn't good enough at that time, and maybe that they were reworking it, but you want things quick. You don't look at the generations of people of our fight that make things happen. But the study has been done. So now it's just a wording and a proper strategy. The first time it was not. But again, let me tell you, I testified in 2002 for a study of reparations, 2002. So 23 years later, they're reworking it. The HR 40 bill was in Congress for over 35, 40 years. It never moved, never got the votes. It's a long, protracted struggle. But you want things to happen quickly to benefit you, not even your children. Right? How do I know that? Well, some of us have been working too hard to put food on and housing for our families and not been able to provide the necessary resources, homeschooling, after school, participating in organizations to make community centers, none of that stuff, right? For our children. And so our children suffer the next generation while some of our parents get fly, party, have other children out of wedlock. You know how boys do, right? But no, you can't criticize our situation. You can't, right? Even if you want to make it better by simply signal boosting, if I want to use that term, things that we need to fix. Because, a black man, you can't criticize a black man. That's fighting words. You can't tell a black man that he's doing something wrong. You could definitely tell a black woman what she doing. You Abrahamic faith type Old Testament Negroes. But you can't criticize another black man. You're not going to criticize Abraham for even the fact that he was going to sacrifice his son because his male God told him so, and then joked with him and said, "Nah, I didn't really mean that. I just wanted to see if you was with me." That's homo association. It's inbred in the black man. But what about our children? What about the next generation that might be able to do this? Because our next generation, we are going to, this next 4 years, we may not even see historical black colleges after the next 4 years, right? This next 4 years is going to be a monster for our people. But you want to argue about some damn tweezers and Kemet. Something I wrote the.
All right, family. So let me just wrap this one up with and I'm gonna cook his blog. So where were we when he testified in 2002? You can't criticize him, all of this stuff. Here's the thing. The thing is movements grow, evolve, and they get refined. So being the first doesn't make you right. And he was not the first. That's just he's lying saying that. So anyway, gatekeeping turns off all of us. You dig? We're not behind this Grim Reaper. He kills movements. He's a Grim Reaper of movements. Okay. He ignores the power of our mass social media mobilization, which helped make reparations a national issue post 2019. You dig? Us mobilizing. So here's the thing, though. Here's his hypocrisy. He admits local reparations are happening. He used that to show FBA isn't stopping anything, is helping push the national conversation. He praises Tone and Yvette for using legal and political strategy, but ignores that FBA is demanding codification from Congress too. He admits freedmen had standing. You can argue FBA is a modern update to precisely that tradition. All right. So now let's get to this horrible article thing he pushed in here by Dr. Jahi Issa, another tether, and this tether right here. Okay. So let me just tell you, this is a bunch of nothing, outdated information. It's a nothing burger. I would love to discuss this with him. This is terrible. It was a nothing burger, garbage, waste of a time. You're better off reading the cat in the hat. So, in summary, what this article was talking about was he and Issa, this other tether, had a 2017 article that contributed an interesting reframing, right? He's reframing. He's treating post 1808 slavery as an illegal transnational crime. Illegal transnational crime. And it rightly urged fresh legal scholarship in the reparations fight. However, the piece exhibits notable logical and historical flaws. It overstates the legal novelty. Prior advocates had truly ignored the illegality of the slave trade under international law, right? It mischaracterizes key historical facts, all right, like the authorship of Amistad, and it sidesteps major legal obstacles, sovereign immunity, standing, etc., that will confront Brother Reggie and Dr. Jahi Issa's strategy. Now, catch this. This is what they're all about. They're all about this. Sad. So the conflation of a Pan-African ideological stance with the specific legal claim for U.S. reparations is perhaps the article's biggest conceptual mistake. It risks undermining the focus and legitimacy of the claim by stretching the claim beyond U.S. jurisdiction. This article is about stretching reparations claim beyond U.S. jurisdiction, and they are muddying who the injured parties are. Family, this whole piece of shit nothing burger article is about including tethers who had nothing to do with slavery in America. They're stretching this reparations claim beyond America's slavery. Okay. And finally, as the reparations conversation has evolved in recent years, it has done so largely outside the paradigm the authors propose, right? They're outdated. So lineage-based reparations are indeed seen as the way forward, lineage-based, right? So this article is goofy and everything before lineage-based reparations is outdated and goofy. Okay. But through political consensus, building and targeting policy, not right. So that means through political consensus and building and targeted policy, not by resurrecting a 200-year-old court cases that they're trying to do. They're stuck in the past, man. The article's call to resurrect reparations through court has so far not borne fruit. It's a nothing burger. The article's call to resurrect reparations through courts has not so far borne fruit. Meanwhile, reparations is being resurrected in the arena of public policy and civic discourse. Thus, while the authors, these two tethers, deserve credit for emphasizing law and lineage. So now they're getting credit for talking about lineage-based stuff. That's us. Meanwhile, hating on that, but he used it in his article. So they are framing, or their framing contains significant flaws and omissions that limit its practicality and have been overtaken by subsequent developments in the reparations movement. This is a absolute nothing burger garbage article that he's bragging about. And he want to talk about scrutiny. Dude, are you serious? All right. Yeah. So his garbage is done. His approach to reparations is garbage, outdated. It's no different than I bet you he bigs up in Cobra at some point. But his main issue, family, his main issue is that the code being the leader, the lineage being the leader, has made all of these old men and women upset because they grew up in times where it had to be a leader. So they already hated Tariq for their own personal reasons. And then when Tariq said, yeah, nah, let the code be leader. Ain't nobody leader. I'm not the leader. Nobody's leader. Oh my God. That is what did it. Because they was hoping that Tariq would claim leadership so they can fight him for that. He did, or even Charlie Kirkham. But since Tariq said, nah, you don't need for a leader. It's the lineage, it's the code, and we just spokesmen and spokeswomen. All these fake Pan-Africanists and these tethers, oh my God. They are mad forever because of that. And now they're trying to make Tariq the leader so they can still come at somebody. Hey man, compare me to him. It's like, yeah, we don't have a leader. It's no comparison. Oh no, but he's your leader. No, we don't have a leader. And we keep telling you that over and over and over, but you need to make us a leader. So now when they finally accept Tariq's not the leader, what they do next? They make Malcolm X a leader. But Malcolm X said. So they try to make Malcolm X the leader. They got to make somebody the leader to attack and to show how they're worthy to be our leader. These are nothing burger clowns, man. Nothing burger clowns. That's what they are. And so anyway, so thank you for pulling up for this live. I'm gonna do at some point. I'm gonna do a live cooking on Jared Taylor and Turk. Now I'm just saying I'm gonna fact check that the same way, but there's a lot of things to tackle. So we got Salida, American Indian. If they can't kill all of us, yeah, they need a right. They need a leader. Okay, first class citizen says yes. He does look shocked. G, he look like Shock G of the Digital Underground. It's funny. Humpty Hump. Yeah. We got FBA Convo. We got Avatarians. Damn, 2.0. FBA Convo, Laura Mall, Taya Tay Carter. You dig Will Yesharon, Bantu Mandinka. I know this live today was like kind of informational, kind of a lot of reading. And it wasn't your typical entertaining one, but thank you guys for standing with this one as well. That's called On Code. You dig? It wasn't the most entertaining live. Aspiring Heights, peace to you. We got Jesse Paris, aka Chet and Kruma. He said Dr. Oba Tashaka. Don't forget him. Let me look that person up. You know I do. Ray in the building. Ricardo Flott. Zambi in the building. Who else popped through? Tandria Williams had stopped through, and some other people I won't be able to look at because the chat only go but so far. All right, let me see who this Dr. Oba Tashaka is. Oh shit. Oh, he want us Kemet guys. Oh shit. Twin. I'll check him out. I'll see what he got. He looks like a nothing burger. But let's see what he's talking about. It's like he's about a lot of Egypt shit. I'm judging a book by its cover in this one. All right, so family, Carlos Magus checking in. We got Bantu Mandinka. All right. Yeah. So this guy right here is terrible researcher, terrible reparations. He's no scholar. He's a scholar in tetherism. That's about it. All right, family. As I leave you guys, make sure you subscribe. Well, you already subscribed. Make sure you like the video. All right. We'll be back with another one shortly, maybe 4 or 5 o'clock. You did 4, 5, 6 o'clock, something like that. Peace.